three blogs, I've been talking about a softball injury that happened at a U.S. Army National Guard outing, and it involved a significant injury to a 13-year-old. Well, the 13-year-old had claims for his physical injuries, and because the judge found the government, through its supervising officer, 80% negligent, the boy was able to recover 80% of his injuries, and that would include projected loss of earnings as he were to grow up, as well as some medical expenses, and finally for pain and suffering and so forth. But the parents, as I say, each, the mother and father, had a claim for loss of consortium against the government for the child's injuries. It's interesting because years ago you could not recover, a parent would not recover for the loss of consortium of a child. Then the law started changing, and children were able to recover for the loss of consortium of their parents when a parent was significantly injured. And finally, the Massachusetts state legislature acted and permitted parents to make a claim for loss of consortium when the children are injured. And here in this softball case where the boy suffered significant injuries, the judge reviewed the amount of work, especially the mother put in trying to care for and help the mother, reviewed the emotional impact on the significant injuries of the emotional impact on the parents of the child's significant injuries. And the judge gave reasonable, it seemed to me, amounts of damages to each parent in their own right for their loss of consortium, separate and apart from what the judge awarded for the child. In the case of the mother, the judge awarded $150,000. In the case of the father, the judge awarded $75,000. Now, it's a matter of some interest to me and perhaps to you that because the judge found 20% comparative negligence on the boy, as I had described in the last blog, the boy's damages got reduced by 20%. But in Massachusetts, the other claims, that is the parents for loss of consortium, their damages did not get reduced by the comparative negligence of the child. I've had experience with those situations, and indeed this case against the U.S. government shows once again that negligence on the part of the person who is physically hurt, any negligence on their part will not be imputed to people asserting a consortium claim, either a claim for loss of marital consortium or a claim that the parents have for loss of the child's consortium. It's deemed really an independent claim, though it depends in part on the physical claim, but it's independent and is deemed that it should not be reduced by the injured party's comparative negligence. Well, the point of this, aside from the fact that it's baseball, aside from the fact that it's negligence against the U.S. government through its supervising guardsmen who supervise this game, the point of this is that these consortium claims offer additional means of recovery to additional parties who are acutely affected by the injury, in this case, to their son. Thank you.